It's the Law.
Welcome to It's the Law, a program produced and presented by the Guyana Association of Women's Lawyers. On this program, we are given an in-depth look at Guyana's laws. On today's program, we hear from Denise Hodge.
Good afternoon, Guyana. My name is Denise Hodge. I am the Vice Chair of Guyana Association of Women Lawyers, previously the Treasurer. Today, we will focus on rights when legally married and under the common law union, the law related to such. The Married Person Property Act, Chapter 4504, sets out property rights and obligations of married persons and persons in common law. By this act, the Supreme Court is empowered to make orders upon an application of a party when that relationship is severed. The act applies to matters of both legally married men and women, as well as single and unmarried persons who live together in a common law union. For instance, Section 15 of the Act provides that a man and a woman who are legally married, as well as a single man and a single woman who have lived together as a common law in a common law union, can apply to the court for an order regarding title to a property as well as division of that property. It should be noted that this act does not apply if one of the party is legally married to someone else. So either a man or a woman legally married or living together in a common law union can seek division of property anytime within the marriage or union or within 3 years after the union ends. Examples of orders that a party can ask of the court include declaration of who is the owner of the property, declaration of someone as the part owner of the property, possession of the property, sale of the property, and division of the proceeds. This latter one relates to when the parties cannot agree on who will give cash sum equaling their interest in the property. And note also, property includes land, any building, vehicles, household appliances, etc. When an application is made before the court will consider a few things. This includes the length of the relationship of the parties, whether the party who's claiming before the court worked outside of the home. If the parties have lived together for less than 5 years, the court would consider the contributions that the party would have made to the marriage, the well-being of the family, and looking after the home. Note that if the parties were together for more than 5 years, then the party did not work out of the home, the court may award 1/3 of the property to that person. As against, if that person would have worked outside of the home, he or she is likely to be awarded 1/2 of the property. In the cases where either party owned property prior to the marriage, they would continue to so own those property. However, where a property was bought in both persons' names, that is jointly, each party will own that property in an undivided half interest. And though it might be difficult to get a buyer to buy an undivided share, one of those parties can sell his or her undivided half share without the other's consent. In addition, where one party dies, the other will automatically own the deceased share, thus becoming the full owner of the property. There are some other rules regarding ownership of property in marriage. For instance, if a man legally married to a woman purchases a property in her name, there is a presumption that it is hers. However, he can rebut this presumption. However, if a woman legally married to a man buys a property in his name, she is still the real owner. The husband can, however, rebut this presumption by proving to the court that she had bought it for him solely. Interestingly, where a wife or a husband has bought a property in his or her name, it can be sold without the other party's consent. However, a claim can be made before the court regarding how that property is disposed of, how the party wished for that property to be disposed. Now let's look at when a husband or a wife dies. What happens to his or her property? If that person dies without a will, he or she has died intestate, as against if that person made a will before they died, indicating how they wish that the property ought to be disposed of, then the executor or the executrix so assigned is responsible for disposing of the said estate according to that will. However, where someone dies intestate, Section 5 of the Civil Law of Guyana Act, Chapter 601, provides for how his or her property is disposed of. In essence, if that person was married, his or her wife has a right to benefit from 1/3 share of the estate. So, this is all we'll share today on this topic. Thank you for listening.
You have been listening to It's the Law, a program produced and presented by the Guyana Association of Women's Lawyers. The contents of this program are not to be taken instead of legal advice.